Madam Deputy Speaker, who'd have thought a government led by a human rights lawyer would be leading the charge to remove one of our most basic human rights, trial by jury? This government is removing the right to a jury trial for any offences that carries a likely sentence of less than 3 years, supposedly to reduce the backlog of waiting cases to go to trial. But let's look at the evidence. There is a backlog of 78,000 cases. There are around 1.3 million prosecutions in England and Wales every year, and 10% of those cases go before a Crown Court. Of those, 3 out of 10 go to trial. These reforms mean that there will now be more than 2 out of 10 still going before a jury. So from those figures, there is no realistic impact, change to those waiting lists from what they are doing, removing a fundamental right. I mean, who was doing the maths from this? The Lord Chancellor, mastermind Lord Chancellor. No wonder the Prime Minister appointed him. But look, my constituents of Tatton, from school pupils to the leader of the Northern Circuit and barristers from the Middle Temple, urged me to speak today to say that this was an absolute disgrace and to put forward some of their suggestions. So from the barrister at St. John's Buildings, who said, actually, I don't believe at all that cutting of a trial by jury will get down these lists, will sort out the problem. In fact, I'm deeply concerned that such proposals will further erode the trust of the public in our justice system. It will remove their participation in criminal justice, and there is no evidence it will make any impact on the delays. A better way, solutions which would stop and stop this backlog, would be to stop the cap on the number of days that can be set. Let courts sit around the clock, and also sort out the failure of the prisoner transport system that doesn't get defendants to court, or they get them there late and wastes time. Now, further, another barrister, a criminal barrister from King's Counsel at Lincoln House Chambers in Manchester, said, I'm very concerned that curtailing jury trials is based on no credible evidence at all. In particular, there has been no pilot scheme. It appears that the suggested savings of 20% has been pulled out of thin air. And very importantly, it will erode a deeply entrenched constitutional principle that a jury may acquit as a matter of conscience in these cases. It will remove a bulwark against misuse of the criminal courts by the government and those in authority, and the ability of a jury to take a view favourable to a defendant for reasons other than the evidence of guilt. And what about the Lord Chancellor? Until a few weeks ago, he believed in juries too, jury by trial. And one thing that backbenchers on the opposition should really take into concern is, constituents have said to me that for such an important change to our unwritten constitution, there should have been mention of this in the Labour Party manifesto. Because that would have factored into my, and this is his, voting decision, and it could well have been, if not, it would have been a very different decision. So the debate today has been very revealing. No data, no impact assessments, no pilots, and the Minister herself, who even suggested... Order. Speaking limit is now 3 minutes.